Welcome, everybody. Today, we are here to talk about workplace harassment in BC. We've got two amazing guest speakers who I will introduce in just a moment. They are David Brown and Linda Ferran. My name is Paula Price. I'm with the People's Law School, and I will be moderating today's webinar. So if you have questions about bullying and harassment in the workplace, you are definitely in the right place. What you can expect today, we have 60 minutes together. We are going to answer common questions about harassment and bullying in the workplace. What we're sharing today is legal information, not legal advice, that is current as of today. And if what you're seeking is the law as it applies to your particular set of facts, then we'd invite you to reach out for legal assistance. You are welcome to contact our speaker, David Brown. His contact information is on the screen. If it's a question that involves WorkSafe, we have their bullying and harassment information desk on the screen as well. So please feel free to reach out. Now, we are grateful to work on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations, whose peoples continue to live on and care for these lands. And we would encourage and invite all of you to consider the land from which you are joining us today. We would also like to acknowledge our funders, the Department of Justice Canada, the Law Foundation of British Columbia, and the Notary Foundation, whose funding makes production of today's webinar possible. And last but not least, we would love to welcome and thank our speakers. We have David Brown. David Brown is a lawyer with Ascent Law based in Kelowna, British Columbia. David is a return speaker to the People's Law School. He joined us at the beginning of the pandemic. He helped us out when the rules around benefits were changing daily with the unexpected challenges of the pandemic. David his practice includes assisting workers who have been wrongfully dismissed, experienced discrimination or harassment, or injured at work. And he is a major contributor to community endeavors like Kelowna Community Resources, the BC Human Resources Management Association, and of course, us here at People's Law School. Hello, David.
Hi, Paula. Thanks for having me. Thanks for the introduction.
Thank you so much for being here. We'd also love to welcome and thank Linda Ferran. Now, Linda is with WorkSafe BC. She is a bullying and harassment lead officer. Linda has been with WorkSafe for 30 years as of this May, 8 years in the work around bullying and harassment. And prior to that, she has been an information officer, occupational safety officer, fatal and serious injury lead investigating officer. And we need to give Linda a very special acknowledgement for being here at the last minute. I think Linda learned this morning that she would be joining us today. So a big thank you for stepping in, Linda. Welcome and thank you.
Thank you, my pleasure.
Thank you so much. And I would also like to acknowledge Teresa Ternowski, who is also with WorkSafe. She was originally going to speak today. She was unable to join us today, but Teresa has done a wonderful job of helping us prepare for today, including coming up with the lion's share of the questions that we'll be going through in the prepared session. So a big thank you to Teresa, who's not with us, but for whom we are very grateful. So with that, we are going to turn to the questions that we have prepared today. And the first question is for you, David, and it's really an introduction. What is workplace harassment and bullying?
Yeah, thank you. Thank you for that. And there's a couple of ways of looking at this, because you can certainly look at this question through the lens of workers' compensation, which of course Linda is best to speak about. Then you can also look at through the lens of any kind of ongoing contractual obligations that employers have with their employees, as well as any kind of as well as under the BC Human Rights Code. It can also be a form of discrimination. Now, generally speaking, though, workplace harassment and bullying is any kind of workplace behavior that's intended to intimidate or humiliate. It's generally speaking a series of actions. All that being said, it can be a single action as well, but normally what we would see is that there's going to be an ongoing pattern of behavior that kind of contributes to this environment of intimidation and humiliation. Now, Beyond that, though, within the human rights scope, is that if the behavior in question is related to a protected ground of discrimination, so for example, if someone's being bullied on the basis of their gender or their sexual orientation or a physical or a mental disability, then that can as well form workplace discrimination. And as well, we recognize that all employers have this ongoing obligation, both under the Workers' Compensation Act and under contract law, to provide for a working environment that's conducive to a healthy and a safe environment. And so if behavior is so serious that it ruptures the relationship between the employer as well, it can bullying and harassment can actually be a form of termination. So I will, that's kind of my short version of workplace bullying and harassment.
Thank you, David. And the next question is, what are some examples of what workplace harassment or bullying might look like?
Still with me? So as I alluded to, it certainly includes like any behavior that's intended to intimidate or humiliate. So this can be as pervasive as using aggressive, ongoing language towards people. It can include body language, or if you're like blocking somebody, or if you're using your body as a form of threat. It can be very passive in a sense, where, for example, if you walk in and you say, "Good morning, Paula. Good morning, Linda. How are you today?" And then you walk right by somebody's desk and just glare at them. That can be a form of intimidation or a manner of humiliation. And of course, leaning in as well to the human rights field, if you have behavior which is gender-based or is based around sexual orientation, so you can just think of some of the terrible names or insults or gestures that we would often associate with discriminatory harassment and bullying, those would all fall within the scope of this area of law.
Thank you so much, David. And I just wanted to note for everyone who's watching that your website has a wonderful write-up about what constitutes workplace bullying and harassment. So we'll link to that in the show notes for anybody who is interested in seeing that. It's a very helpful resource.
Right.
And of course, your answer is also a very helpful resource. This next question is for you, Linda. And the question here is, what role does WorkSafe BC play when there is workplace harassment?
Good afternoon, everyone. WorkSafe BC's primary role is to, with bullying and harassment prevention, is to ensure first that the employer has developed their own policy and procedures to address bullying and harassment. They must have a policy statement that says bullying and harassment will not be tolerated. They need to have clear reporting procedures, including alternate reporting procedures in case the primary person is the respondent in some fashion. And they must have developed clear and consistent investigating procedures so that workers are aware of the process that will ensue once they've made a complaint. We also endeavor to ensure that employers give their workers adequate training in how to recognize bullying and harassment, to be aware of their own policy and procedures, and how to report these concerns. We expect that if specific incidents of bullying and harassment are reported to the employer has followed up or responded in a fair and unbiased manner and in accordance with their own procedures, and taken all corrective actions that are required when necessary. When this does not happen, WorkSafe BC may receive a complaint from a worker that something was awry in their reporting or investigating process. We don't respond to every such complaint, but what we would do when we do is ensure that the employer's policies and procedures are in place, and we would ensure that the employer has investigated the worker's specific complaint according to their own procedures in a fair, impartial, and consistent manner, and that the evidence substantiates the outcome and that their process is reasonable given the circumstances.
Beautiful. Thank you so much, Linda. That's a really helpful explanation of the role that WorkSafe BC plays. I'd also, again, like to draw everybody's attention to some of the resources that are on your website, and we will link to those in the notes, but there are a number of resources for employers and for workers relating to workplace harassment and bullying. Linda, the next question is also for you, which is, when would WorkSafe BC step in to investigate a complaint about bullying and harassment?
We would step in when a worker has contacted us and completed an online bullying and harassment questionnaire. So the BH team officers, who are specialty officers, would be directed to those complaints only. So we're always sort of in a response mode for that. We do not investigate. That's the first, let's get that out there. We do not investigate complaints of bullying and harassment, but we do inspect to ensure that the employer has the policies and procedures in place and that they have done the investigation, as I stated earlier, in a fair and consistent manner. They must adhere to their own procedures in this place, and it must be fair and impartial. So we would follow up with an employer, conduct an inspection. We would conduct 2 inspections, really: policies, procedures, and training, and then the investigation to see if it was reasonable. Our role is simply to ensure the employer fulfills their obligation and completes the investigation appropriately and fairly.
Beautiful. Thank you so much, Linda. And thank you for clarifying the role that WorkSafe is playing, that it's not the investigation, it's the inspection that you've described.
Mhm.
Beautiful. This next question is for you, David. What if you think you're being harassed at your workplace? What options do you have?
Yeah, thank you for that. I think a good starting point is to ensure that you understand what the process is for filing some of these complaints. So as Linda was just describing, every employer is required to have some kind of like policy that speaks to this. Now, unfortunately, not everyone does, but they're supposed to have that. And that's going to be a very good starting point to understand what kind of options you have available to you. Now, the thing about addressing these kinds of internal concerns is that being silent doesn't help often, right? So depending on the circumstance, depending on the severity of the harassment, I would say it could start by confronting your harasser. And a lot of times it can be as simple as that, by just saying, like, I really don't appreciate this. I want you to stop. And it could end it right there. Now, that being said, not every circumstance is going to dictate that, right? There's going to be a lot of times where that's not going to be an adequate resolution, either because there's a power imbalance that might exist, or because the person is just so uncomfortable with coming forward with these kinds of concerns. So in those kinds of circumstances, generally speaking, you would follow the reporting procedure that's going to be laid out in employer policy. Typically, that would mean filing a complaint with a manager, or it could involve going to human resources. Generally speaking, the complaint would need to be formalized in some context. So it could be that the employer would accept a verbal statement, but more likely than not, they're going to require some kind of like written statement as to what's occurred. And then at that stage, the onus really does kind of shift onto the employer. There's going to be a duty for the employer to conduct, as Linda was saying, like an impartial investigation into the course of conduct that triggered the complaint. Okay. Now, there are going to be some additional circumstances as well, which might open up outside avenues. So for instance, if your employer is not taking your concerns seriously, or if your workplace is so toxic that it really has put in jeopardy the viability of the employment relationship, or if your employer, maybe your direct supervisor or your manager, is the harasser, well, what do you do in these kinds of circumstances there? Again, the opportunities that would be available to us. It might mean, going around your supervisor and reporting to somebody who's higher up, or it could mean going out to an outside resource. So in limited circumstances, that could include WorkSafe BC, as Linda was describing. It could also include, depending on the nature of the harassment, going to the BC Human Rights Tribunal and filing a complaint with them. Finally, I would say is that if you're working in a toxic environment and you're unable to get the remedies that you're looking for, your employer is unable to provide you with a healthy and a safe environment to conduct your business in, you can vote with your feet. You can leave, right? You can resign. And in those circumstances, there might be some avenues available to you. One such legal avenue might be called what's called a constructive dismissal, where basically what this means is that the employer's conduct created an intolerable relationship with a working environment that you're not expected to be in, and you can basically declare that you've been fired, you've been dismissed. As well, that could include other forms of litigation like a human rights complaint or a complaint with WorkSafe BC. Finally, I would say a lot of people who are experiencing harassment have psychological impacts associated with the bullying and harassment. Again, depending on circumstance, there might be a wage claim available to them through WorkSafe BC. There might also be an avenue to explore long-term disability benefits or medical employment insurance. So a lot of information there, but certainly if you are being harassed, there are informal and formal recourses that can be followed.
Beautiful. Thank you so much, David. And just to recap for everybody's benefit, you started with confronting the person who is the person who's doing the bullying, who's doing the harassment. You have reporting through the company's own policies, procedures. The third being reaching out, if appropriate, to WorkSafe or to the Human Rights Tribunal. Next option, potentially legal action, maybe in the form of a constructive dismissal claim. And then the last option being, if it's something that is impacting your ability to function, it may be reaching out to, it may be a WorkSafe type, it may be WorkSafe, it may be disability. So is that a fair?
Yeah, I mean, if it can be demonstrated that the harassment was, originated in the workplace, in those circumstances, there may be able to make a wage loss claim with WorkSafe BC. Otherwise, if there's a long-term disability provider involved, if there's like a complicated constellation of reasons for the disability claim, LTD might step in as well. I mean, it's all very case and fact specific, but speaking to an advocate or a lawyer or to a WorkSafe BC officer might provide some clarity.
Beautiful. Thank you so much, David. And I'd also like to point out the People's Law School website has a page that is dedicated to helping look at the options to deal with problems at work. So you may also get some ideas there about how to take some steps or what actions you might take. Following up on one of the situations that David mentioned, Linda, this question is for you. And what happens if your boss is the bully? Who do you make the complaint to?
Well, I would take this question in different ways. There are many bosses in a workplace, right? Most people will report to a supervisor, possibly a manager. In those cases, this is good because there are always alternate persons to report to you. You can keep climbing the corporate ladder and making your formal complaint to the next higher level. However, the employer is the one who the worker must be making a complaint to. So their reporting procedures should set out instruction on who else the complaint can be made to or who to make it to at the next level. We've seen workers go from reporting to their supervisor, which may go nowhere, to the union, who, unless their procedures are through the union, can't really help them but advise them. And in those cases, they should definitely document, make a formal written complaint, submit it, even if it's to the bully themselves, because it's a small organization and there is only one boss or an owner. Do it anyway. It shows that you have done your part, and it provides evidence down the road to show what the response was. At that point, if the employer does not respond properly, please contact WorkSafe BC. That is the type of situation where we would be able to instigate an inspection. And in case nothing is being done, we would ensure that a fair and impartial investigation is done, even if the employer has to retain an independent third party to do so. Okay.
I piggyback on this answer. I think it was a fantastic answer, Linda. Do you mind if I chime in, Paula, quickly?
Please.
One of the challenges that we often face in the workplace is that there's a lot of different workplace stressors that we experience. Some of it can be related to work demands. Some of it could be related to like receiving some kind of discipline or performance feedback, or even news of like a termination or something along those lines. And it's important to recognize that when somebody is properly acting within their capacity as a manager, even if that information is hard to receive, even if it does, humiliate us to receive negative feedback, it would oftentimes fall outside of what would be considered bullying and harassment. Sometimes there can be a very fine line between being a demanding boss and pushing your team and pushing your team and pushing your team and demanding expectations, and being a bully. So I'll just leave that there, is that, typically exercising management discretion is not bullying. And so that can be a conflicting issue here when we're specifically talking about a boss.
Yeah. Thank you both. Thank you, Linda. Thank you, David. I think it really is a sensitive area, and I think you've both done a really great job of explaining it from different perspectives even. This next question is for you, David, and it follows up on what we've been talking about, right? When you're in that situation, for example, where maybe it's harsh feedback or maybe it's bullying, and really, how do you know? At what stage should you reach out to a lawyer? And is this the kind of question that you might be bringing to a lawyer if you have a concern?
Yeah, so I guess there's a couple of ways that you can look at this. When people are going through these acutely stressful workplace situations, we can often have an initial call with somebody and talk to them about strategy, talk to them about communication style, talking to them about their next steps, right? So we can be engaged when somebody is still actively employed and they're saying, this workplace is intolerable, I don't know what to do. And they can come and talk to us, and we can say, okay, well, let's talk about, internal reporting, taking this to your manager, or going around your manager, talking to like your manager's manager. We can help them draft those letters, prepare them for those meetings, explain to them what they can expect in a workplace investigation that deals with bullying and harassment. So we can get involved in all of that. When people think of a typical litigation lawyer, though, we're usually getting involved when the employee has kind of completely exhausted internal remedies, or when the problem kind of gets too big for them to handle on their own, right? So in these kinds of circumstances, if you reported a complaint, a concern, and it's still ongoing, or you face some kind of retaliation, there are mechanisms there where we can kind of counsel you on what next looks like, going forward with a prohibited action complaint through WorkSafe BC, going forward with a human rights complaint with the BC Human Rights Tribunal, or possibly even assisting you in making the decision that I'm declaring that this relationship is over, I didn't sign up for this, and putting in place a legal strategy to try to get some compensation for you. Those are important decisions. And I certainly want to recognize that there are tools out there and resources out there to help people with this. But, if you're thinking of declaring a constructive dismissal, there can be very real personal impacts that flow from that decision. I think it's a very good idea to get proactive legal advice. Likewise with filing a human rights complaint, even if you're continuing to work within the relationship, filing a complaint puts a tremendous amount of stress on that workplace relationship. And you're going to need some assistance in governing that.
Absolutely. Thank you so much, David. I think that's a really helpful and impactful answer. Linda, this next question is for you. Again, a potentially difficult situation. What if your coworker was investigated and they were found to be a bully, and yet that coworker still continues to be employed at your workplace? Why didn't the employer fire them?
Well, actually, a normal outcome for a bullying and harassment investigation is that both the bully and the complainant will continue to work in the workplace. The idea is that the employer needs to address the concerns appropriately, come up with a clear decision, and develop recommendations if there was bullying and harassment to be found, or even if it wasn't. But problems were identified with the manner in which the supervisor talks to people. Perhaps they don't have any experience or training with that. Then it's up to the employer to target specific recommendations to assist that worker, the bully, to overcome them and coach them and work with them. Right? That's their right as well. As a result of that, they will go back to work in the workplace. That's why it's very important for the employer to contact the parties in the investigation at the conclusion and let them know that it is concluded. This is our finding. We cannot share with you all of the recommendations that we have made. A lot of these are private matters of discipline or private conversation with a respondent. And they may be occurring and the complainant is not aware of that, right? So it's good to have that conversation post-investigation. That is when the complainant feels nothing has been done, if they don't see things to be done. WorkSafe, however, has no jurisdiction over management decisions in the workplace. So management, they own this company. They can run this company as they see fit within appropriate guidelines and conventions and the law. We do not dictate if discipline is imposed. We often, as with any safety violation, we suggest that there is a discipline policy, and I don't know of any employers who really don't have one or would not implement one. It's a natural thing. We cannot interfere in the scheduling or termination of workers. We would focus on whether the employer has followed the reasonable steps in our policy and procedure to address the complaint, and including cautions and supervision and training to ensure that there isn't a repeat. However, if there is a repeat or any type of retaliation, the appropriate course is, and sadly, is for the worker, the complainant, to make a new complaint. Sometimes an employer may wish to take action. They may feel this is the first incident and they don't have enough background to make that kind of terminal decision, right? It's a big deal. And it's not easy to let somebody go. It really isn't. It's easy to do it. It's difficult to substantiate it and to follow it up afterwards, especially in light of a complaint having been made and being a retaliatory action, which we'll talk about later. But this will commonly happen. And it is a challenge for a complainant, absolutely, to go back into a workplace after they've been off for a few weeks or have an interview, see the investigation, come to a conclusion and go, well, they're here, I'm here, what's going to make it different? He's just going to do it again. So they may feel that way, but that's not necessarily the true state of events. And at that point, I think my caution to workers, complainants is please be objective. Don't assume everything that happens is as a result of this. And have a little patience, give it a chance. There are many relationships that actually can improve and be very productive and collaborative after. But it will take some time. In many cases too, an employer may provide a mediated meeting between an independent mediator to try and address the issues and make it easier for people to return and work together. That's the ideal outcome. If the respondent continues in this unhealthy manner, future incidents will be treated in a different way. The employer will have more basis, more history in which to impose subsequent discipline, but that is not something that WorkSafe BC can prescribe. Okay.
Beautiful. Thank you so much, Linda. And I think, a couple of things that I take away from what you just shared with us is, number one, is the expectation that a complainant will have going into this, that even if they are found to have been harassed or bullied in the workplace, that this does not necessarily mean that the person on the other end of it is going to be terminated, that their employment would be terminated. And second of all, to your point about returning to work with that open mind and seeing what happens, and if it is required, to follow up with a further complaint, and that puts the employer in a different situation. They have a different sort of factual framework that they are now working with, and so for everybody who's in this situation to sort of be wary of beware of what their expectations are, or what the roles are of the various players who are involved. So I think that's really helpful for all of us. Thank you. This next question is for you, David, and we touched on this earlier as well. What is the difference? Where do you draw the line between what might be a stressful working environment and what amounts to workplace harassment?
I think a lot of this is going to be very subjective. It's going to be depending on the circumstances and the individual involved. One way that I would look at kind of redefining a stressful working environment and a toxic workplace is I like to kind of go back to base principles in law. And so what I mean by that is we recognize that all employers, all employees have obligations to one another. Some of these obligations are found in law. Some of the like the Workers' Compensation Act and like the Human Rights Code. Some of these obligations kind of just flow from the natural working of our relationship. So where an employee has an obligation to show up on time and do their job to the best of their abilities and follow reasonable instructions and so on, an employer has an obligation to provide an environment that's healthy and respectful, and that is built on trust, and is one that is and is going to pay the person their wages and so on. This creates the foundation of the relationship. It's a contract, right? Where I give you my time and energy, and you give me a paycheck and a healthy environment to work with them. So when an employer is failing to live up to their end of the bargain, where an environment is toxic because of bullying and harassment, because of discrimination, because of chronic overwork or whatever else may contribute to that, and the employee has signaled this, saying, this isn't working for me. Like this is creating an environment that is unreasonable and that I cannot continue to work within. If there's not reasonable efforts to remedy that, I think that can inevitably lead to a workplace breakdown. For me, it fundamentally comes down to this idea of trust, right? Relationships of all kinds are based on this idea of trust. Working relationships are no different. If I don't trust my coworkers, if I don't trust my employer, that's almost certainly going to lend itself to an environment that's toxic. If I don't believe that I can take their words at face value, or that they'll follow through on commitments that they'll give to me, or that they're going to provide me with an environment that's healthy and safe and providing a psychologically safe space to work within. That's different from stress, right? I have a stressful job. We all have like very stressful jobs. A WorkSafe BC officer that's conducting investigations of workplace accidents has a stressful job, but that's different from a toxic job, from a toxic environment. And I guess to kind of come down to it, to me, is the working relationship able to endure? Have I given my employer the opportunity? Have I engaged in that communication to allow the employer to modify the relationship necessarily? And if not, am I justified in basically leaving my post because of that? Again, everyone's individual experience is going to be different. People have different stress thresholds, have different, some people are not adverse to having difficult conversations or adversity or dealing with workplace stressors, or other people are. And so it's going to be a very subjective answer that you'd be looking for here.
Great. Thank you so much, David. This next question is for you, Linda. And the question is, my employer investigated my complaint. I'm not happy with the outcome. What can WorkSafe do?
Okay. This is a common issue. I'd like to compliment David on that wonderful answer from the earlier discussion. I was listening keenly. That was a wonderful answer, by the way. What I wanted to talk about in this particular question, if the employer has investigated the worker's complaint, has received it properly, been sensitive, provided support, conducted interviews, assessed the evidence that was provided, made a reasonable decision based on the evidence in a fair and impartial manner, and came to a conclusion, WorkSafe BC will have no business in this particular investigation, because there is no violation reported, there is no issue reported. People have, again, as David said, they have different levels of awareness, tolerance, past history, and expectations around that. And that needs to be moderated. People need to keep bringing themselves back to an objective place if possible, and learn new skills possibly in returning to the workplace and working happily, healthily, enjoying your job, and making an effort to collaborate and cooperate. The respondent may feel terrible about what's happened and may want to mend things over, but you need an opportunity to do that too, right? So sometimes the complainant can turn into a bit of a bully, right? This can happen unawares. We are not in a position to be a body that reviews a management decision in these matters. Many of these outcomes, as David referred to earlier, are simply not bullying and harassment by definition. They're part B of our definition, which excludes management control and direction of the workplace and management decisions. So if management investigates a complaint, and really what it is performance management, which can go on over a period of time and is very uncomfortable, that's the truth, and very humiliating, it's still not bullying and harassment, unless it's very bad management style. There certainly is performance management that can be bullying and harassment, but it needs to perhaps, for example, be done in public. Make public humiliating comments about performance. Well, that's different, isn't it? It's not behind closed doors. It's not done in a confidential, respectful manner. So there's the difference. Also, oftentimes, workers and employers will have over time created what we call ongoing disputes. Okay, and they can take many faces, many things. Again, we are not getting involved in long-term disputes that have to do with hours of work, preferential job treatment, that kind of thing. That's not us. However, workers who feel that the employer has arrived at the outcome without having done a fair process, without having utilized their consistent procedures, with not having interviewed witnesses or obtained all the evidence that is necessary to make their decision, should absolutely contact one of our specialty officers on our information line and talk about the circumstances, see if there's any back and forth conversation we can assist them with to go back to their employer to get their questions answered. And if we feel that they have presented us with something that could be a violation of these requirements, we will absolutely take this file on and become involved and initiate an inspection. Your first step should be to consider if there are questions you need to go back and ask your employer about. And secondly, don't hesitate to call the information line. It's for information. That's where you should go.
This next one is for you, David, and it's, I complained to my union and they didn't do anything about it. Now what?
Yeah, this is a great question. And it's a really challenging circumstance. I got a lot of sympathy for people who are going through this kind of situation. I guess to begin with, when you're dealing with a union, you have to be the source of the communication you need. So sometimes just writing an email to like your shop steward or to your national rep is not going to suffice, right? If you're facing ongoing workplace challenges, bullying and harassment, you got to be the squeaky wheel. These people got lots of items on their plate. Things often fall off, and it can start by saying, I've got this ongoing issue. I want to talk to somebody about this. Wait a day or two. Just following up. I need to, follow up with you on this concern. It's not going away. A week later, I want to file a grievance. There's this ongoing problem. I view this to be a breach of the collective agreement, and just continue to push and push and push and push and push until you start getting some traction. Of course, going to your union doesn't prevent you from going to management as well. Ultimately, health and safety it's an employer obligation primarily. And so if you're facing bullying and harassment, it's not only a labor relations issue, but it's also a health and safety issue, and that can be that can go directly to management. Sometimes as well, it's important to recognize that unions are in difficult positions in that they can represent and have a duty to advocate on behalf of both the complainant and the respondent, which can be very uncomfortable, put it that way, right? So be mindful of that. Finally, what I would say is that if you are the squeaky wheel, if you're trying to make these advances and come forward with like a legitimate grievance about workplace health and safety, and it's not being treated seriously, you can ultimately file a complaint with the Labor Relations Board. That would be provincial. If you're a federal employee, it'd be what we'd call the Canadian Industrial Relations Board. But going to these organizations, you can file what's called a complaint of the failure of the duty of fair representation. Okay, and what that basically means is that unions have a duty to fairly represent their membership. That means representing them in such a way that's not discriminatory or not arbitrary or not in bad faith. And if you feel like you're not being treated fairly for these reasons, you can go and file a complaint with the Labor Board. Very tricky. I'm not going to sugarcoat it. These are really hard complaints to make. You might want to think about getting some advice before doing so. But I would say, more than anything, be your own best advocate in speaking to your employer and your union.
Beautiful. Thank you so much, David. Next question is for you, Linda, which is, my doctor told me to take stress leave from work and call WorkSafe BC. What happens next?
Well, interesting. By the time a worker feels the need to go to their doctor to talk about their stress level, it is fairly evident that they've allowed a situation at work to go on for some time. It's not new, and they just can't take it anymore. There may be an event that has occurred which has sent their anxiety into overdrive for the moment, and they go see their doctor. I would never suggest to a worker that they not take their doctor's advice. They must decide if that is right for them to do. if they want to take time off. They can also file a claim for mental stress with WorkSafe BC. But both these scenarios, the worker must notify their employer that this is occurring. They must notify them because this is like a first aid incident, basically a medical attention incident. It's required by regulation to be reported and documented. The employer may have to conduct an investigation. They will have to respond to the claims department with wide variety of information. And this may actually be the incident that triggers a bullying and harassment investigation if they had not been aware that this worker was suffering from what they perceive to be bullying and harassment. Not a lot goes on in terms of an investigation if a worker is not around to participate. It can provide some delay. A worker generally needs to be available to be interviewed and to provide follow-up or feedback during the process of an investigation. And an employer is not going to be calling a worker at home on sick leave to fill in blanks. That in itself could be considered harassment in many cases, and it's simply not done anymore. The employer needs to have this reported to them. They need to know the worker went to the doctor. Workers should be aware that they should never have days of work unexplained. Okay, if they need to, if they get a 2-week leave and they feel there's no way they can go back for another week, they need to see their doctor before that leave expires, especially if things are getting testy at that point at the workplace. You can have sick leave, but once it's turning into a longer term, the employer does have the right, and this is a legal perspective, so not mine. David could speak to that, but they have a right to have some sort of idea if you're coming back, and a rough idea when, even if it changes. So stay in communication with the employer. File a claim. Our claims department they work quite differently than us. Depending on the circumstances and the allegations made as to the cause, the stressors causing the mental stress or the workplace stress, they may have a field investigator go and conduct interviews with workers and the employer, or obtain documents or evidence to see if they can substantiate that the mental stressor was actually a workplace stressor. Okay, that's the key item for them. And does this stressor far exceed the normal day-to-day type stress that a worker might be exposed to at work, which at times, as we all know, can be excessive, right? So that is a key thing to keep in mind. The process claims uses is quite different from prevention or field services, which is health and safety, which is where I work. And it's not intended to make determinations if bullying and harassment has occurred. So that still remains to be the employer's determination in conducting their own investigation. Oftentimes, workers are afraid to return to work until the investigation is over, but they do need to be mindful that an investigation is a participatory event for that worker. They need to be available to provide their evidence and rebuttal, and at the same time, and more importantly, they need to protect their own health and their own mental health. Sometimes an employer will ask a worker for a doctor's letter before they even return to work, and this is a due diligence item on their part. And the worker should comply with the employer's requirements and their disability requirements if they have any. But I'm going to stop on that point because I'm breaching into legal areas, which is not my specialty.
Super. Thank you so much, Linda. And we've just got a couple questions, and then we'll turn it to the live Q&A. Hopefully we'll have some time for that. The next question is for you, David. I don't feel safe going to work, but I need the money. What should I do?
Yeah, so again, there's a couple of options here. I guess we should kind of break it down as if there's some kind of like mental stressor, which is preventing the return to work. So if somebody is experiencing some kind of like acute mental disorder as a result of workplace circumstance, they can they may be able to apply to WorkSafe BC, as Linda was just describing. I've already previously talked about filing a claim through their long-term or short-term disability programs. There's also a program through employment insurance where you can receive medical insurance, medical employment insurance. And that has a duration. I'm going to get this wrong, but it's 15 or 16 weeks, it's approximately 4 months, where somebody can receive some kind of ongoing income support through that time. Now, I want to just touch on something, because I'm really, I often stress like individual agency here as well. If you are fundamentally unhappy at work, yeah, you might have legal avenues available to you, and you might be able to get some money out of those legal avenues, but they're a lot of work and they can cost a lot of money, and they're definitely stressful. If you feel like your work environment is not safe, or you feel like you're just fundamentally not in the right spot, or that your employer doesn't have your back anymore, you always have the option of leaving. Right now, we are experiencing the strongest job market that Canada has seen in decades. And there's acute labor shortages across the board. And a lot of people are leaving jobs and transitioning into new work very quickly, and often making more money than they ever were before. And so I guess you're never without options is one thing that I want to impress. You can go to WorkSafe, you can go back to work, you can work with your employer on trying to find a healthy working environment. You can file claims in the right circumstances, but one option that's always going to remain is nobody is chaining you to your desk. You can always move on.
Super. Thank you so much, David. And this next question is for you, Linda. And as you answer, I just want to let you know I'm going to unshare my screen, because the next part is the live Q&A. But this question is, can I get fired if I complain and there wasn't a finding that there's a finding that there wasn't harassment?
Well, you certainly should not. If any complaint is made, it should be addressed appropriately, as we've said before, by the employer. But there are a couple of things to think about that. It needs to be made in good faith and not frivolous or malicious. Okay, so these are things that are, let's very simply, these are very bad things to do, to make complaints of a frivolous and of malicious nature. Okay. However, having said that, complaints that are made are good faith, they're addressed. No, there should not be any process for termination. Maybe some coaching at most about what bullying and harassment is or is not. What there should be are subsequent investigations by employers if frivolous, if vexatious or malicious complaints were made, or untrue complaints were made. That should be taken very seriously by the employer. All right, that is no joke, and it happens. The raising of a health and safety concern in the workplace is a protected right, and that includes bullying and harassment. It is enshrined in the Workers' Compensation Act through the prohibited action complaint component, which is another avenue. That's not to say that they will not try to fire you, or you know, that they won't do it. They can still try, they can still do it. But that doesn't make it right, and that doesn't mean you don't have recourse. They can change the terms or conditions of your employment. So in many cases, that will be a legal matter. But it would, or a constructive dismissal, it would also constitute a prohibited action under the Act. That is something WorkSafe BC would address, and you can do it in concert with other kinds of complaints. In fact, you can have a lot of things going on at the same time. All these things that have been brought up today can occur simultaneously. Yeah. So sometimes it's hard to keep track of them. You need a notepad to write down all the things you have going on. And especially when you're stressed and distressed, it's really difficult to do that. But again, you can talk to one of our harassment officers, and they would be happy to explain the difference for you, help you take some notes, get the numbers, get yourself organized. If you experience actions from your employer as a result, retaliatory type actions, dropping your shifts, losing status, losing projects, you're on the night shift now, whatever, being terminated. And if there can be a cause and effect that can be shown to occur temporally is usually the easiest, best way. Please complete a prohibited action complaint and contact an officer to discuss it. The same thing applies with a union. As David was saying earlier, you can make a complaint of prohibited action against a union. It's an employer or a union. And it doesn't even have to just be your own employer. If you're in a workplace where there's a prime contractor, and the prime contractor decides that a worker of another employer needs to be gone as a result of a prohibitive action, you have a complaint against them as well. Okay, so it gets very complicated, and you do need to talk to people and take notes and take some sort of responsibility for decisions as to how you're going to proceed, what you're going to do, and basically get advice is my advice.
Excellent. Thank you so much, Linda. My first question is, this is for you, Linda. Who does WorkSafe BC inspect if the perpetrator of the bullying and harassment is the same person who's supposed to be implementing the policies?
That doesn't really change what we do. The employer and employer, even if it's a small employer and there's one owner, they wear multiple hats and they have the same responsibilities. They have to put on their management hat, their investigator hat, their discipline hat. This is what's done. For bullying and harassment, they may need to avail themselves of an independent third party to come in and investigate this complaint. If things cannot be fairly investigated in-house, the information's been corrupted, there's relationships, the fairness is, unlikely, or understanding is unlikely, then this is what WorkSafe BC would definitely get involved in and ensure that that's done. And we would review the investigation, see that it's reasonable and so forth. Does that answer the question? Did I grasp it properly?
I think so. Thank you very much, Linda.
If I can just add to that, a great answer, Linda. I really appreciated it. I think employers also need to be sensitive to actual bias and perception of bias, because both are dangerous, right? So if for example, there's a complaint made against someone who's in a leadership position, and there's an expectation that the HR manager or whoever's been tasked with investigating this can't do it objectively, even if that person is doing it by the book and completely objectively, if it's going to compromise the optics of the investigation itself, in those cases, you would often look to an outside investigator to get help. Keep it clean. Yeah.
Thank you so much, David. This next question, also a receiver of many upvotes, and David, maybe we'll ask you for this one. How do you address subtle verbal harassment from a supervisor?
Yeah. So I think we touched on this briefly. I would start by setting healthy boundaries, right? So if somebody is issuing subtle harassment, where appropriate, and if you are comfortable, I would start by saying, cut it out, stop it. I don't like this. If you continue with this, I'm going to have to escalate. I don't want to do that. So that kind of direct communication, I understand some people are not comfortable with it, and that's okay, but it can also be incredibly effective, right? Just by boundary setting and saying, what you're doing is not okay, it's offside, and I'm not going to tolerate it any longer, right? And I think there, if the behavior is ongoing, then what you're going to do is you're going to come back to kind of basic principles. Okay, so if I'm either uncomfortable in boundary setting, or the person's not responding to my boundary setting, then who do I bring this to within the organization? As Linda mentioned, providing a healthy and safe environment is an employer obligation. So what we can do is we can then signal to somebody who's in a position to assist that this is ongoing. I've made these attempts to resolve it. I'm uncomfortable with the status quo, and I'm looking for intervention to assist in this. And that would usually trigger some kind of investigation. Now, I want to be clear as well, like an investigation doesn't need to mean that, we're going to bring in like, some police officer or bring in like Matlock here to look under every stone and review every document. It can be quite simple. It can be as simple as having a conversation with the complainant, having a conversation with the respondent, having an understanding of what occurred, and putting in a plan of action to resolve it. Like, you don't need to talk to everybody in the organization, right? Oftentimes it's best to keep it as low key and discreet as possible. Anyways, I'm kind of going off track there, but that would be my recommendation, is if you're dealing with a supervisor and you can't address it on your own, you escalate. You bring it to somebody who can help you.
Super. Thank you both. And there are a lot more amazing questions. I'm going to ask one last question and then we're going to wrap up for today. So the question is this: how does one gather evidence of bullying and harassment? I have noticed that this can be very difficult for an employee to gather.
Shall we both try at this with different perspectives?
Sure. Yeah.
So for WorkSafe BC, for harassment investigations under the Act, this is an administrative law process, obviously. The deciding factor is based on a balance of probabilities. Did it occur, right? It's a low bar. It's 50-50 pretty much. So keep that in mind. If you go to your employer with a complaint, this happens all the time, about something that's happened, and it cannot be corroborated by any other means, it is extremely difficult, it is impossible for an employer to make a decision based on the allegation. If things start to get tricky at your workplace, if you know this feeling, something's going on, somebody's starting something, this isn't good, start making notes. You can pull up Notepad in your phone. You can do it on your computer. You can do it wherever you like, a little scratch pad in your pocket. Have it ready, have it available. Make a note. Make a note of the time and place, the comment, who was there. Look around, look around. It's like a car accident. We never look around to see who the witnesses are. And yet that is what we need when the time comes to address it. That's who we desperately need. And if there's nobody, guess what happens? So look around, take down a few names, keep it private and confidential, continue. If you speak to the person, if you say, oh, excuse me, what did you mean by that? What did you mean by that comment? I like this one. This is my favorite. What did you mean by that? And in public, where people are, if they've said it in public, I say it in public. And it almost draws attention as well to the fact that there was something, and then people will be aware that you've said something and go, oh, okay, write down what the response was. Of course, you can go to your employer for assistance. Like David said, not every response is a full-blown investigation. It can be an attempt at mediation and coaching, but if you need to make a formal written complaint. You need to document everything about what happened and what people's responses were, who was around. My advice also is to email your personal email or keep copies yourself in case at some point in the next weeks or two, you no longer have access to your work email. Maybe you're on a leave, a stress leave, maybe you're suspended and you don't have access to the things that you feel you could use as evidence. Keep records, make notes, be aware, collect, be a collector, okay? But don't forget that you're involved in this process as well. And anyway, I'll turn it over to David for his legal advice.
Thank you, David. And just as you do that, I'm going to share my screen so that everyone has the last bit of information that we're sharing. So David, over to you.
Yeah, so thank you, Linda. A lot of very good tips there. The underlying theme here is create records. Now, keep in mind, records can look and feel like different things, right? So one tip that I often give is, people say, well, if I'm in a conversation with somebody, there's no document saying that, or I don't have a witness to confirm my side of the events. Well, I say, well, when you leave that conversation, make a note of it, or even better, send an email if you're comfortable doing this, saying, send an email to the other party saying, we just got out of this conversation. I just want to confirm my recollection. Do you have anything to add to this? Right? Because now what you've done is you have a timestamp. This is what you've confirmed that's happened here. You're giving an opportunity to the other side to correct the record or to make any amendments. And that can be, incredibly valuable when you're looking back at this, 4 months later as to what happened on the day of, right? Some things that you can also keep mind of: text messages are records, emails are records. One thing that I'm seeing increasingly, and it's controversial, but everybody has a recording device in their pocket. And I'm seeing more and more and more often where people are recording conversations. They know they're about to head into a heated conversation. They've got their phone in their breast pocket or in their trousers or in their whatever, and they click record. I'm not going to pass judgment on that. It's very controversial. It's certainly not helpful to constructive employment relationships, but it's evidence and it's legal. Okay, so just be mindful of that. I'm a big fan as well of journaling. So if you're having it's kind of a last matter, have a handwritten journal or a typed journal and just describe what your experiences are.
Beautiful. Thank you so much, David. Thank you so much, Linda. And thank you, everybody who has joined us today. We are going to wrap up. Thank you, everybody. And we'll look forward to seeing you again. Bye for now.